All right. Good afternoon, everyone. I'm just letting people enter into the webinar. Okay. Um, Good afternoon, everyone. Just a reminder that this webinar is being recorded and it will be available on the MVLS website soon after as a YouTube video, as well as the PowerPoint slides will also be available to you all after the webinar. So welcome to our third Thursday training. My name is Asia Mallory. I am the senior staff attorney here at Maryland Volunteer Lawyer Service. And today we have the Holland Law Firm with Manny Turnbull, and Jess Russell here to provide us an excellent webinar on identity theft and fraud in consumer cases. So hopefully you will learn a lot of information on how to deal with this issue and some of our consumer cases that we're seeing here at MVLS. If you have any questions, please feel free to put the questions in the question and answer chat box. All right. Manny, you are free to take it away.
Okay, hi there, everyone. Thanks for joining us. I'm Manny. I'm one of the partners at the Holland Law Firm. And this is Jess, our associate, who does a lot of the debt defense work and does it very well.
Good afternoon, everyone.
Okay, so we're going to talk first about the kinds of identity theft and fraud that there are to deal with. We're going to talk about defense issues, how to beat cases involving identity theft and fraud. We're going to talk about investigating these issues, and then we're going to talk about what to do after you've won your defense case, how to bring affirmative cases to challenge the institutions that try to collect on identity theft debts and generally make people's situation worse. Okay, so what are the kinds of theft and fraud here? There are lots of different ways that you can divide this up. You can talk about the nature of the thing being stolen. Medical identity theft, credit cards, loans, mortgages. There are even people who commit identity theft for the purpose of avoiding criminal conviction. They pretend to be someone else when they get arrested. Mostly we're going to be focusing on the kind of thing that comes up in consumer law more often, which is financial accounts, often credit cards. Yeah. You can talk about how the theft is perpetrated. Is it a new account being created by the thief? Or is it a genuine account that the victim has that the thief gains access to and then uses for their own gain? You can talk about who does the theft. Is it someone you know or is it a stranger? Typically, a case involving a family member is going to be more complicated and harder to deal with than a stranger who's just going around opening accounts because they can, because they've discovered enough information to do it. And then there are some other kinds of things you might think of as fraud that don't really reach identity theft. So someone who is tricked into doing a transaction that's fraudulent. Someone who gets a text message saying that you have to pay right away $1,000 using a green dot card to get your sister out of jail or something. That's not identity theft. That's just fraud. That's a scam. And unfortunately, those situations are very hard to get people out of. And sometimes it can be very hard to tell the difference between identity theft and a mistaken identity. Mistaken identity is going to be where a collector, an institution, pursues your client over an account that actually belongs to someone else. It's especially a problem for people with common names and for children with the same name as a parent. If there's confusion, if social security numbers are close, sometimes the wrong person gets collected on. That's not ID theft, but it's very hard sometimes to tell what it is until you get into the case. So those are the different kinds. Uh, so what do you do when you get one of these? So let's imagine that you've taken a lovely case from MVLS. There's a defense case. Someone is being sued by a creditor who says that they owe money. And the client story is, I have no idea what this is. Over to our debt defense expert.
All right. So you've got someone who's come in, they say they don't have any idea what is going on with this account. They don't recognize it. Or they say, this was my account, but I haven't used it in months. I haven't seen any of these transactions. They weren't me. You want to have a good grasp, first of all, if this is a genuine account that's been taken over by a fraudster, or if it is an account that has just been completely created by someone fraudulently. And there's a couple of things that you're going to want to go into the case knowing. First is your basics, contract law, agency law, burden of proof and standard. We'll get into that a little bit more. But you also want to be familiar with the Truth in Lending Act. And the Truth in Lending Act limits the liability of cardholders in instances of fraud, but it also, very importantly, shifts the burden of proof to show the legitimacy of transactions onto the plaintiff who's seeking to collect, not on your shoulders. Debt collectors love to pretend it's the other way around. They love to make you feel like you're in the position where you are trying to prove a negative. This wasn't me. This wasn't authorized. And we'll turn to the Truth in Lending Act in a moment. There's some facts that you also want to start looking at when you're interviewing your client for the first time. You want to know if there's a police report. You want to get an idea of what kind of things were going on with the account. Sometimes they won't have statements. Sometimes they'll only have statements that were provided within the context of a debt collection case. And take a look at what you can. If there's a police report, that's great, especially if that's led to some sort of charges being brought against a fraudster. That's really your gold standard, I find. But a Federal Trade Commission ID theft report completed by the client is also something that is usually helpful to have, at least to provide some sort of evidence that, hey, this is fraud, this. As soon as the client knew that it was fraud, they went and took steps to try and report it and to make it clear that this was in dispute. There are some other things that you can look at when going into these kinds of cases. Looking at those statements, we got it on here as buying gold bullion in Idaho. Sometimes it's very clear that the kinds of things that were going on with the account were fraudulent in nature. If you have a school teacher who lives in Baltimore and hasn't left the state for 10 years, they're probably not going to be buying big ticket items that have a pretty reliable resale value outside of the state. They probably aren't going to be ordering DoorDash in Barcelona, as I saw in one case. And those are the places where you can start to build out a little bit better in terms of discovery, in terms of drawing together documents in preparation for a case. So the first thing to do, once you've got a pretty solid idea of what kind of identity theft it is, and that it is, identity theft is, you're obviously enter your appearance, draft your notice of intent to defend, make sure that notice of intent to defend says in a very clear way that this is identity theft, that your client is not responsible because of that. And I always like to include a demand for strict proof. that ask for a copy of the original application for credit. Sometimes you get those from plaintiffs, and it's just crystal clear that this is contact information, a signature that bears no resemblance to anything going on in your client's life. And that acts as a very clear indicator that this is an identity theft case. I also, if there's an opportunity to file or seek any kind of discovery, I will always seek discovery. Debt collectors don't tend to be very good at discovery. They do cases by volume and maybe play a little fast and loose with the exact standards, maybe not as closely have closely read the rules. And you can create a lot of pressure in litigation by being really on top of discovery and following up with motions to compel, motions for sanctions. You can get a case dismissed if they fail to follow through on discovery to a significant degree. And that can be just as effective a way to get rid of a case as as going through trial and having a judge dismiss it because they failed to meet their burden of proof. Let's turn to that burden of proof now. So you've filed your notice of intent to defend saying, hey, this is identity theft. You've put the plaintiff on notice, and you have filed some discovery. That discovery is seeking information about the account statements, any disputes that they've received from the client or that said, hey, this was a fraudulent account. They may have in their system somewhere a fraud investigation detailing whatever steps they took in response to that. Hey, this account isn't mine, it's fraudulent. That shows what they did to investigate it, if anything, and what the outcome of that was, and you may get from that some valuable information that you can use later down the line. If you're in a small claim, or if you're coming into the case after the window for seeking discovery has closed, you can do this through a trial subpoena. Trial subpoenas are great. They are not discovery. They are governed by an entirely different section of the rules. Debt collectors don't like to acknowledge that sometimes. I'll address that more later. But again, you want to seek documents, original application, statements showing activity, any communications with your client, including but not limited to any disputes of the account related to fraud, and any investigations as well as their findings that were conducted by the plaintiff relative to those disputes. Can we go to the next slide? So when you get to trial, the burden of proof is on the plaintiff from the get-go. They've got to establish that there was an account. They've got to establish that it was with your client and that there's activity that wasn't paid as agreed. And that's just their normal standard. When you assert the identity theft defense, they also now have to prove that these were legitimate transactions, and that the activity on the account was either by the defendant, that it was authorized by the defendant had some knowledge or had given consent for the account to be used or opened in the way that it was, or, and this one's where you sometimes, particularly with family members, run into some issues, that account or the use of that account in some way benefited the defendant. So if you have a case where a parent opens up an account in the name of a child with the child's details, child doesn't know, child didn't authorize, but child's school expenses, child's birthday present, some activity on that account ended up benefiting that individual whose account the name, or in whose name the account was opened, that may be sufficient to say, hey, look, whoever opened this, whatever the circumstances of its opening, ultimately the person who benefited is the person whose name is on the account. And that can get get you into a bit of trouble where it's a case where a family member has used your client's identity to open an account without their knowledge or consent. There are limits on liability. So it's not that if there's fraudulent activity on a credit card that okay, everything's completely written off. They can get your client for up to $50. Beyond that, they're not liable. And that is contained in the Truth in Lending Act, 15 U.S.C. 1643. We've got the brief section here on the slide, and you can refer back to it later. See, liability not in excess of $50.
Right. But even the $50, of course, that depends on meeting the other criteria for that.
Yeah.
So it's not just they can always get $50. There's other things that they have to do to get it. And frankly, I don't think I've ever seen a collector bother trying for the $50 if they're not going to get the rest.
Yeah. Go on to the next slide. So a couple of things that collection attorneys will often try on. They will get to the, I've had it in more than one instance where you get to trial and you get to the eve of trial and they say, oh, well, I need to investigate this. I need to find out more information, run it by my client. Don't give them more time. If they can't prove their case, which it sounds like they can't, why give them extra opportunity? And more often than not, the eve of trial is not the first time that they have been given notice of the identity theft claims. I had a case where my client had done multiple disputes with a credit card. They filed their case. We filed a notice of intention to defend. And then months later, on the eve of trial, I get an email saying, oh, wait, this is identity theft? We need a continuance to investigate that. There have been 3, 4, 5 different times that this has been brought to the attention, including emails between counsel. But they act like it's something new. And in that particular case, it was annoying because they filed for a continuance, didn't give me service via MDEC. They mailed it less than a week prior to trial. The continuance was granted, and I showed up because I didn't get notice through MDEC, even though it was an MDEC jurisdiction at the time. And they seek these continuances because they don't have the goods, generally speaking. They've treated it like your bog standard collection case. They haven't gotten copies of the fraud reports, probably haven't gotten copies of what you've subpoenaed them to bring to trial on the day of. And it's a bid for more time. Speaking of trial subpoenas deuces take them. I have had collection attorneys come to trial and either refuse to give me copies of the documents they've brought pursuant to a properly served and executed subpoena deuces tecum, or not showing up with documents at all, saying that I can't have it because there's no discovery based on the size of the claim or the time that it was filed. Again, subpoenas are not discovery. They are governed by an entirely different section of the rules. And they also, importantly, aren't subject to the same limitations as discovery. I have had debt collectors try and have subpoenas quashed on the basis that they were seeking documents which they did not feel fell within the scope of discovery within the district court. Obviously, that was not correct. But that limitation doesn't exist in the subpoena rules. It is the discovery rules, and they will try to misapply to misapply the rules from time to time if it gets them out of providing documents. And last but not least, sometimes they will try and say they will victim blame. Yeah, this is the defendant's fault. They should have looked at their statements more closely. But so what? It's the plaintiff's burden to prove the case. And saying that the defendant lacked knowledge is not sufficient to meet the standard to prove that whoever was using the card was the agent of the defendant sufficiently to prove that they were authorized, that the plaintiff had knowledge, or that they benefited from it. That's that they have to meet that before they can move on. So let's
Right.
see.
They'll say, well, she didn't read her statements, Your Honor, so it's her fault. That's the way it's presented in court. And of course, the rejoinder is, so what? Not
Yep.
reading the statements doesn't give you a contract with these people. It doesn't make the charges authorized. And if you didn't know about the charges, you can't have ratified them.
And someone in the chat has pointed out Rule 1201. It's an unjustifiable expense and delay. Unfortunately, from my experience, judges are all too willing to grant continuances over the objection of the defendant. Apparently, these plaintiffs are just too big to follow the rules, too big to get their act together in time for trial.
Yeah. It's very
Which
dependent
is
on your judge, isn't it?
endlessly frustrating.
Yeah. I had one who took, I think, the right line and said, when was the notice of intent to defend filed? Oh, 2 months ago? You've had time to investigate. I'm not giving you continuance. And another sort of, given the dog ate my homework sort of excuse from a bank's counsel, with the defendant's husband and someone from the sheriff's office there to testify at trial, says, well, okay, but I'm going to give them a continuance. But, it had better not just be, oh, we disagree. And if it turns out to be that, then I think you should have to pay the attorney's fees for these people. And suffice to say, it did turn out to be, oh, we disagree. And they dismissed the case before the revised trial date came on.
To that same end, when I get into these cases, after I file, at some point when I get in, before or after filing the original notice of intent to defend, if I have contact information for the attorney on the other side, and I have something like a police report or FTC report, even if I don't, I like to reach out and go, hi, I'm getting into this case. It's identity theft. You should dismiss this with prejudice. Here's the FTC report. Here's the police report if it's available. And if I don't get a response, follow up on that maybe a week or two later. It depends on how long you have until trial, but give them ample opportunity, ample notice, leave no doubt as to the fact that they have been told that this is identity theft. And then you can, if they move for a continuance, you can submit a stack of emails saying they shouldn't get it. Here's 4 months out, 3 months out, 2 months out, 1 month out, and they come to me the week before and ask for a continuance? No, they've had plenty of notice, they've had plenty of opportunity. And that can also be helpful when you get to the affirmative cases, which I think Manny's going to talk a little bit about later.
Yeah, so let's talk a bit about digging into these ID theft situations a bit more. We've kind of covered some of this already, talking about the FTC reports. An FTC report's really easy to do. People don't need a lawyer to do that. Identitytheft.gov is the place you go for your FTC report. And all they have to do really is fill it in and try not to get anything wrong. Because it is a report to law enforcement. It is something that is made under oath. So they can potentially be liable if they lie on the FTC report. Whether to make a police report, that's a bit of a question sometimes. Some police departments are very unwilling to take reports related to identity theft, especially if they perceive it as an attempt to get out of a debt. I suspect this is partly because it's very hard to catch a stranger identity thief. And for some people, not particularly in Maryland, I think, but in some areas, there is a concern that the response of the police will be to try and pin it on the victim, or say that the victim was somehow involved. But if it's a stranger identity theft type case, I would probably encourage a client to make a police report and try to get a copy.
As
Okay.
Manny said, it can be difficult to get the client to want to make a report to law enforcement when it's a family member and they perhaps found out after the fact and don't want to have negative consequences for that family member, though they really were the victims of identity theft and don't want to or can't pay the account for their family member, and the family member can't pay either. And that's something that may need further client care. And
It is a difficult question. One thing I've had people ask is, well, I kind of know that X did it, but I don't want them to go to jail. What do I do? And of course, a person in that situation, they're still entitled to put accredited proof.
Mhm.
But what consequences that will have for their family member is very difficult to say. Another issue you get with making police reports is sometimes the police and the state's attorney will be relatively unwilling to prosecute family members.
Yeah.
I think partly because they worry that the victim will reconcile with the family member and refuse to testify and sink the case. And it does happen. People do reconcile with their abusive relatives sometimes, in identity theft as in other situations. So that's another problem of familial identity theft. So anyone who has an identity theft issue should be checking their credit reports. They should be getting their file disclosures from annualcreditreport.com, which is kind of the official gateway for those things. A couple of reasons to do that. The first one is to make sure there's nothing else out there that they don't know about yet. If someone's been a victim of ID theft once, they could well have been a victim multiple times and not yet discovered it.
Mm-hmm.
And it's better to discover these things earlier than later. You might also find that there's bad information related to the identity theft on their reports, like fake addresses they never lived at. You might also discover that what you thought was identity theft is actually mistaken identity. You'll see that there are name variations and social security number variations on their report. And that might point you in the direction of saying, well, actually, it's not ID theft. It's just that people are confusing your client for somebody else. In some cases, it's worth getting specialty reports. So specialty reports are like credit reports, but for other things. There are specialty reports for almost everything. Personal property insurance, prescriptions. There are ones for landlord-tenant screening, employment screening. There's even one that tracks people who cheat at casinos. So if there's a reason to think that one of those areas is implicated, if, for example, your problem is that that the identity theft is say a residential rental ID theft, someone's rented an apartment in their name, you probably want to go checking those specialty reports to see if there's anything else out there.
Yeah.
And ultimately, your client is going to have to try and get those reports corrected. Otherwise, the fraudulent accounts are going to hang like a millstone around their neck when they try and do things that require these reports.
And there is the potential to block fraudulent accounts from showing up on some of these credit reports. And that can be an incentive to file something with either a police or an FTC ID theft report, because there are requirements for having some sort of report to law enforcement in order to get that block.
That's true, that there are Fair Credit Reporting Act implications here for both credit reports and specialties. Realistically, your client has the best chance of getting something off their report if they have an FTC report or a police report, or ideally both. But even that will often not be enough, unfortunately. Okay, so if this is the kind of case that involves a forged signature, obviously you want to see examples. Ideally, you want examples from before the case was filed, so that there can't be an accusation that they've sort of changed their signature. And ideally, you want them from around the time of the fraud, the time that the fraudulent signature is dated, because signatures do change gradually over time.
Sometimes it's real obvious.
Yeah, sometimes it will be painfully obvious, especially car dealer forgeries. I don't know what it is, but they do a very bad job of forging signatures.
That'll be great, because there'll be usually a number of contracts that are put in about the same time, where the first signature had one set of terms and was the authentic signature of the client, and then the car dealer decided to mess around with the loan terms, mess around with some other aspect, and the signature is just completely different, night and day, on two different contracts that are a day apart. And
Right.
very clear there.
Then the flip side of it, though, is that if it's a known party ID theft, the signature will often be a lot better, because the thief has an opportunity to look at examples. They may even have the opportunity to trace a genuine signature, which is going to
They
be very hard to detect.
they may have been practicing getting out of class for years with by forging mom or dad's
Right,
signature, you know.
right. And in fact, one case I was involved in, the identity thief was a known party, and subsequently a box was discovered where they'd been practicing forging the signature and manipulating documents. So there's some investigation you can do there if it's relevant. Statements, obviously, you're looking for those fund transactions that are either obviously dodgy or which might be provable about who did them. So you don't want sort of convenience store transactions. You want, hotel reservations, airplane tickets, people who'll keep a record that will have someone's name attached to it.
Yeah.
That can be a double-edged sword, because sometimes the thief will have used your client's name, but it can be worth looking at. Now, by the time people get to you, often they will have already tried to fix this, and you want to see what they did, what they said. If you're lucky, they will have written a nice ordinary person kind of letter saying, "It's not me. I never had this card. I didn't do this." If you're less lucky, they will have hired some credit repair organization that will have sent out, crazy sounding letters to all their creditors, and that'll be a problem. And then you want to look at the responses that they get to the dispute. Usually a dispute response from a creditor is just going to be "No, we don't believe you." But sometimes there'll be a bit more to it. They'll include some documents. Maybe they'll show you a signature and say, "Well, hey, you signed it." And those can be useful.
They don't often give you a lot of information where they do a response, and something to be on the lookout for is, I have had at least one case where the bank's fraud investigation was pretty much limited to calling the bank where payments had been made on the fraudulent account. So sometimes, particularly in cases of known identity situations where it's a family member, they may a stranger might be trying to get as much as they can out of a single person's identity as quickly as possible and then abandoning an account. Whereas someone who's a family member might be using credit on a recurring basis and making payments on fraudulently opened cards. And in this particular case, the extent of the fraud investigation was to call the bank that and make inquiry about the account from which payments had been made on the fraudulent card. And it was a jointly opened account, an account that where the client's name had been put on that account, never had access to it, never made payments from it. But the bank concluded, well, your name was on the account. You must have ratified any activity because you were making payments that suggested you knew about this. There's nothing to stop an IT theft who can open a fraudulent credit card from opening a fraudulent bank account, and you may need to do some further investigation from that point on. Particularly if there is some sort of response to the fraud dispute saying, hey, no, this is yours because you made payments. Another thing to be aware of is sometimes your client will not write a lovely written dispute and give you a document that you can then hand over to a judge. A lot of people, they see something wrong, they flip over the statement, and they call the number on the back and make a dispute verbally. And there are records that are associated with that kind of dispute. Often the creditor will send a, hey, we got your dispute and we're investigating it, we'll get back to you, kind of letter. Sometimes the client gets it, sometimes they don't. There's probably a log somewhere in there in the creditor system, but that usually isn't something you should expect to actually receive going into a debt defense trial. An affirmative claim is another creature. I'll let Manny talk about that more.
Yeah, so payments is an interesting point actually, because it's a pretty common misconception that payments on an account suggest that it's legitimate. Even if they're not payments that can be specifically associated with the victim, there are people who will say, well, why would a thief make a payment? And there are a number of reasons that thieves will make payments, especially if it's a familial ID theft. Usually the goal isn't just to extract the maximum value from the account and then run away. Often a thief is opening accounts, they're doing things in order to use the account as though it were normal, as though it were theirs. And so, of course, they make payments. They just sort of see themselves as borrowing their relatives' credit.
Yeah.
And even in cases where it's unknown party ID theft, sometimes payments will be made in pursuit of some larger scheme. One thing you might see is a payment made on a credit card in order to lower the balance and then spending back up to the credit limit, and then the payment bounces. So it can just be another way to extract more value from the account. Payments not at all indicative that the account's genuine. So some other things to look for, particularly in cases involving account takeover, when you're trying to prove, well, okay, the account was legitimate, but these charges are not. You want to look carefully at addresses, because to perpetrate the fraud, the thief wants the person not to get their statements. And they will do things like changing the address on the account, or they will switch it to online only statements so that the person doesn't get the statements to notice the charges. And then if you're looking at obviously dodgy charges, like charges at lots of different Home Depot locations in multiple states in a short window of time, that's probably going to be fraud, but you want to be able to show, well, my client cannot have been in Texas buying a refrigerator on that day because they were at work in Hagerstown that day. And actually looking at what the transactions are is something that some district court judges will do. They sort of have their own opinions about what are likely to be fraudulent transactions, and they'll dig into it a little bit to try and work out, does this look legitimate? So there's some investigation. Here are some things that you want to try and get from the other side. Jess has already covered most of these.
That original account application can be really good to ask for, because I have been told by a witness on the stand, who is supposedly a document manager for a creditor, that they only kept the original application for 2 years after it was made. And they don't have the original application, and then they did not have a signed contract. Their theory was, we sent the card to your client, and that was in their name, and that card was used, and so that card must have been used by your client, and that's how we know that your client used it, was because we sent the card to person that we believed was your client. And we didn't really even get to Tila at that point. The judge said, you haven't proved that this is the person you've contracted with. Judgment for the defendant. And account statements, we've gone into that, looking at the nature of the purchases and whether there's any grounds to say this clearly is not my client. It's nice to get correspondence between the plaintiff and the defendant. That goes to some of those disputes that we were talking about. But also sometimes there will be interesting things in there, like, hey, your card was used at such and such place, and the correspondence is to an email address that was never belonged to the defendant, has no bearing on any part of their life, and can also serve to suggest that, okay, you know, there were fraud alerts, but they went to the fraudster. Oh dear. Something that we haven't touched on in here is the creditor's red flag policies. They are required to have things that raise a red flag when they see it in the account activity to suggest that fraud is going on.
Right. They're supposed to have a list, and it's
Yeah.
supposed to be regularly updated. And there's an example list in the Federal Register, because this is required by federal regulation. But each creditor is supposed to have their own list. And sometimes those red flags will be things that are present in your case. And sometimes their red flag policies will be, frankly, rubbish. They will have red flags that don't really apply to their line of business, especially if it's a sort of shady company to begin with. It's worth asking for these, especially because they won't really want to provide them in the defense context. And it's worth asking for them in the affirmative context, because it helps you prove that they should have known better. Okay, so particularly challenging situations. Familial ID theft, we've talked about a lot. There are a lot of problems in familial ID theft cases. That's not to say that you shouldn't touch them, but you have to be careful and you have to be realistic about it. It can be more of a challenge than stranger ID theft. Often the facts are a lot more complicated. Stranger ID theft very often is one account. Familial ID theft often is a lot of accounts. I've seen cases with more than a dozen fraudulent accounts opened by the thief over a long period of time. So they are going to be more involved and more time consuming. So some fraudulent transaction cases can be very fiddly too, especially these wire transfer cases that you might see quite a lot of. So normally an electronic funds transfer is covered by a statute called the EFTA, Electronic Funds Transfer Act. And that protects consumer accounts to a reasonably large degree. Provided that you notice the fraudulent transaction and you report it, you get your money back. And it's not a defense to that to say, well, it was your fault somehow. They just have to give you money back. But there's an exemption for wire transfers. And so some banks, especially particular banks, have been saying that, well, these fraudulent transfers are actually wires. So we're not going to give you any money, and we're just going to blame you for, believing a call that ostensibly came from our fraud department. Often these wire transfers involve some degree of scamming the victim, phishing to get information. And often the banks will say that it's their fault and refuse to give back the money. And if you want to sue over that, that is going to be difficult. You're going to end up in arbitration almost certainly. There are some approaches to getting around it, but it is very complicated. So don't dive into those cases without talking to folks about them. Okay, more generally, affirmative issues. What are the bases for a claim? So let's say that we've had the situation with Jess. Jess has taken the debt defense case. She's beaten the creditor hands down. The judge has said, well, no, victim doesn't owe the money. Judgment for the defendant. Well, your client is probably still fairly unhappy. They've maybe had to pay money for a defense. They've had to take the day off work. And often they are very upset about what's happened. So what do you do? What are your claims? Well, some obvious bases. The Maryland Consumer Debt Collection Act, MCDCA, and the MCPA, those are good claims. MCDCA, you've got a claim for knowingly attempting to collect money that's not owed, but you also have claims for any act that would violate the Fair Debt Collection Practices Act. And that includes just attempting to collect an amount that isn't owed.
So that's not just the suit, that's any collection letters prior, right, any calls, any attempts,
so that covers,
up to and including.
Right, the totality of collection activity. It's not just the lawsuit. FDCPA, that's only going to apply to third-party collectors. So if they've had, a dodgy debt buyer or some mean third-party collector going after them, or if the lawyers have been particularly bad in the collection action, there's potentially an FDCPA claim there, though watch out for the 1-year statute of limitations. EFTA, that's only going to be cases involving sort of checking account transfers. And the claims there are to do with the investigation. The person disputes it within 60 days. The investigation says, no, the transaction was genuine. You've potentially got a claim there. Fair Credit Reporting Act cases can be very good, but they require disputes to have happened. The FCRA claim isn't about whether the money is owed exactly. It's technically that the investigation done by the furnisher, that's the creditor,
wasn't reasonable.
Was unreasonable, was superficial. And of course, you have to set those up very carefully. You have to make sure that the requirements have been met to have a claim. It's a very technical statute. But if there is a really good FCRA claim, potentially there are uncapped punitive damages, which is pretty scary for a creditor and pretty good for your client. And then if it's a credit card, there is potentially a TILA claim. You can say that the attempt to hold the person liable contrary to 1643 is a TILA violation. But again, you've got your 1-year statute of limitations to watch out for. Jurisdiction can sometimes be an issue. If the ID theft happened out of state and you're dealing with some entity that has no in-state presence, that can be a problem. So if it's like an apartment complex in Georgia, you might have some trouble suing them in Maryland Circuit Court. Standing is a huge problem in federal court. My advice is just file it in state court, and if they want to remove it, they can. And if they then want to argue about standing, your reply is, well, you wanted it to be in federal court. If you've changed your mind, we can just go back to circuit court. And you'll be surprised how quickly they are likely to drop it. Arbitration, you might well end up in arbitration on an account takeover. You might even get motions in a new account ID theft. But that's just another opportunity for you to point out that it's not your client's account. If your client's been sued, that can be a bar to arbitration, because suing over the issue can be a waiver. Okay, what about the facts you need? Well, what are your client's damages? If their damages are sort of shrug, I didn't like getting sued, it might not be worth it.
You may need to encourage your clients to open up about how they were affected. A lot of people are embarrassed about being pursued for a debt, even if it's one that they didn't owe, and will be hesitant to talk about that. And that in and of itself can generate some damages. There are some categories that you're probably going to have, especially if it's gone through trial. Your fees for defending the collection case are their damages in the affirmative. Their days off work and lost wages. Particularly if there was a continuance for the sake of the plaintiff to get documents or do an investigation. Time expended in disputes, time taken off work to pursue disputes. Those are some good places to start before going to the non-economic damages.
Yes. If you're dealing with a transfer case under the FTA, then they might actually have lost money or the use of money. But
And if
often
there's
most of the damages are going to be about the distress and about the credit reporting implications. You know, that they will have avoided applying for things because they're afraid they'll be denied,
or they were denied.
or they will actually have been denied. The bigger the debt is, the bigger a problem that's going to be. And typically, the more urgently your client needs credit, the more it's a problem. You also want to look at, well, how good were their disputes? If it's going to be an FCRA case, the disputes need to meet the criteria. And really, you want them to be enough that the case is going to go to a jury and the reaction is going to be, well, of course this person didn't owe them money. How could anyone think that? That's the reaction you're going for. So you want
Manny,
it to be good.
we've had a question in the Q&A, which I think would probably be good to talk about here.
Yeah.
What's your view on helping the client draft their dispute letter?
Well, if your client is a reasonably articulate person and they've got their FTC report, they can probably be trusted to do a dispute on their own. And in some ways that helps because an articulate person writing their own dispute will probably do as good a job as you will, summing up the issue, especially if it's simple. I never opened this account. I know nothing about it. Here's my police report. I didn't do it. Please take it off. This is really upsetting.
Yeah.
But if the situation is more complicated, if it's, you know, familial ID theft and that there's some evidence to go through, perhaps, that's the sort of situation where you might want to have a go at drafting a dispute for your client. Potentially, that you don't want to be putting yourself out there as doing credit repair and charging people a fee for
Yeah.
writing a dispute letter, because then you might have CROA problems.
There are There are also pretty decent dispute letters available in template form from the
Yeah.
Consumer Financial Protection Bureau and the FTC, which are available on their websites. They give a very clear idea of what goes into a good dispute letter that you can refer your client to have a look at that. I don't have a problem writing a dispute letter for my client, but I also see it as, do they want to invest in my time? Do I want to invest in my time to do something that there's a very good template for that is relatively simple and has been designed to be relatively simple by these consumer facing entities.
Right. There's no magic to it. Provided they
Yeah.
identify the count and explain their dispute and ideally have some evidence to back it up, that's all that they need to do. One plus side of doing the dispute letters yourself is that you get to make sure that they go out the right way and that copies of everything are kept. Clients are often not very good at that. It is important that disputes, if you're going to do them, go out return receipt requested, because you'd be surprised how often they just don't arrive if there's no return receipt. In fact, that there is someone out there who claims that one CRA had a policy of just creatively losing disputes if they got too many in the mail. So there are pluses and minuses. In a complex case, it is probably worth doing. In a simple case with a reasonably good client, they can probably do it themselves and save your fee. Okay, credit scoring, I'll just mention briefly. Having a drop in your credit score is not necessarily a form of damage, but a lot of creditors and credit reporting agencies think that sort of thing is important. They think denials and drops in a credit score that are provable add value to the case. So it's worth trying to find that out. Some credit cards will give you a credit scoring history
Yeah.
over the past year, say, and you will probably find out the credit score if the person gets denied credit because it'll say in the denial letter.
You do want to be careful when using some third parties that will offer credit score information, because you may find that there is a hidden arbitration agreement in things like My Experian or Credit Karma that could create problems for bringing litigation down the line.
Yeah, so arbitration is another big issue, especially with the credit reporting agencies. A lot of people use things like My Experian or My Equifax rather, or they go on the website of the agency instead of annual credit report to try and get a copy of their report. You want to avoid that where possible, because the agencies increasingly are relying on these website accounts to force people into arbitration when they shouldn't really be forced into arbitration. So you want to be careful advising them about that. Avoid signing anything, doing any agreement with one of the CRAs itself, and even some of the third-party entities actually are associated with and have arbitration clauses that will cover the CRAs. Okay, statutes you ought to know. I include these mostly for you to look up later, should you need them. But these are
And we are
citations
coming up on one.
for the common alphabet soup. Okay, we've already talked about TILA. FCBA is the Fair Credit Billing Act. That allows you to do disputes about unauthorized charges on a credit card. It's much like the EFTA. FDCPA, you probably know already, that's third-party debt collectors and debt buyers. The FCRA is all things credit reporting and specialty reporters too. EFTA is electronic funds transfers, not credit stuff. And the MCDCA and MCPA are our very own homegrown statutes. Okay, do we have any questions in the minutes we've got left?
I'm not seeing any open in the chat now, or the Q&A, now that we've answered the one about writing the dispute letters.
Oh, okay. I guess we covered that one. All right. Well, let's see. Any parting things to say? Well, yeah, if you have ID theft issues that come up and you want to talk to someone about them, feel free to give us a call or an email. Or if you have more complicated questions you want to ask outside the scope of the webinar, feel free to get in touch. I'm always happy to bore people about identity theft. If you really want to be bored, we also have some recordings of previous trials that we've done involving these and other issues. And if you want to see what it's really like in these cases in district court, we can maybe give you a sample.
All right.
All right. Well, thanks, Manny and Jess, for this really informative presentation. I learned a lot. If there's no more questions, we will end this webinar. Thank you for joining us on this third Thursday.
Thanks
Thank you
very
for
much.
having us.